an uptick of foreclosures filed by our local municipalities, and many folks have a lot of questions about how to handle it, what kinds of defenses you can raise. And so when Cindy Hendrickson mentioned to me that she had been putting together some materials for her own staff, I was very happy and quick to pounce on an opportunity to get her to present those materials to the rest of the state. And along with Cindy, we have Paul Curtin, who has done some work in Buffalo. There are two different ways that you can pursue property tax foreclosure. There's municipalities can opt in to particular methods, and so Paul and Cindy are going to go into some details about that. So to Paul and Cindy, both of you, thank you so much for helping out with this. Cindy Hendrickson is the managing attorney with Legal Aid Society of Mid-New York in Utica, and Paul Curtin is the joint chief attorney with Legal Aid Bureau in Buffalo. So to both of you, thank you. And with that, Cindy, you are on.
Thank you, Becky. I've been handling property tax foreclosures since 2009, including representing clients in bankruptcy proceedings. And I'm going to talk about the first part of our presentation today, is the state statute that controls property tax foreclosures in New York. And we called our webinar at the 11th hour for two reasons. As most of you know, most of your clients are going to come to you right before a deadline, or sometimes they're going to come to you after midnight, after a deadline has already passed, and they're still looking to save their home. The second reason we use the 11 is because Real Property Tax Law Article 11 is the state law that controls foreclosures in New York State. Okay, just before we get started, there's really a different mindset to property tax foreclosures. When I first started out, I really tried to appeal to the local government, to their sense of compassion. I had some clients with some really difficult hardships, and I just didn't understand why they didn't seem to be responding to that. And the reason is because in New York, property tax foreclosures, if they're following Article 11 of the Real Property Tax Law, it is mandatory. So all the procedures in the law are mandatory, and sometimes the tax districts really just have no choice. They have to follow what the law says. And once I read the statute in full, I understood what they were dealing with. So Real Property Tax Law Article 11, again, it sets forth a procedure for property tax foreclosures in the state, and it's mandatory for all tax districts, except back in 1994, some tax districts were allowed to opt out of the law. And I have a link here to a website that will show you any jurisdiction that opted out. It's still loading, but I can tell you that some of the major big counties upstate, as well as Nassau and Suffolk, are some of those jurisdictions. Also, some of the cities, big cities, such as New York City, Syracuse, Rochester. And Paul's going to talk to you in the second part of the webinar about the opt-out jurisdictions. Those jurisdictions are going to be following their own local laws. Villages that opted out could only opt out through 2009. So if you've got a newer tax foreclosure after 2009, you're not going to have to deal with an opt-out. You'll be under Article 11. Okay, and getting back to the mindset, in mortgage foreclosures, you're used to, even banks, we tend to say that banks don't have a lot of compassion, but even sometimes they do for people that are really in severe hardship situations. And again, with Article 11, sometimes the state law mandates something and they really can't be flexible. And there's really two reasons for this. I came to understand really after reading the statute through and through, and they're actually good reasons. Number one is they don't want the tax districts treating some taxpayers more or less favorably than others. In other words, I'll let my friends pay their taxes off late, but I won't let people I don't know do it, or I'll let this business do it and not the other. Also, ensuring that local governments don't become insolvent. They need to collect their taxes so that they can be solvent and continue to operate. I'm going to tell you right up front that these deadlines under the Real Property Tax Law, Article 11, are very, very strict. And again, sometimes even if your client comes up with all the money and it's past the deadline, the tax district may not be able to accept it. So it's different from property tax foreclosures, and you kind of have to get yourself into that stricter mindset. Myth or fact, there is no defense to tax foreclosure in New York except payment. I've heard that quite a bit, and remember back when the foreclosure crisis just started, a lot of defense firms were telling us that with mortgage foreclosures, oh, there's no defense to mortgage foreclosures. And we've proved them wrong, resoundingly. So actually, it's a myth. Like mortgage foreclosures, you have to provide due process of law in a tax foreclosure in New York State. The difference is that if the tax district follows the procedures in Article 11 to the letter, they're going to be presumed to have provided due process, and that's even if a party did not get actual notice of the proceeding. As long as they follow those procedures, it's going to go forward. And the major case on that is a Court of Appeals case, Kennedy versus Musafa, and I encourage you to read that because it has a good statement of the mindset and reasoning behind that. Okay, how does a tax foreclosure under Article 11 start? Well, what they first do is file a petition for foreclosure, and they can file that in the Supreme Court or County Court. It's a little strange because in a mortgage foreclosure, you have one defendant. In these cases, you'll have one action, one index number, but it's going to be against all the delinquent taxpayers for any given tax year. Anybody that has an interest in the property, and that includes the borrower it includes the homeowner and any mortgage companies or banks that have a lien on the property and anyone else with an interest in the property. They have to be served with a notice of foreclosure and a petition for foreclosure. Now on this notice of foreclosure and petition, there's going to be an extremely important deadline, and that is the deadline to redeem or answer. Moment of truth, redeem or answer. This is a drop-dead deadline. Sometimes, miraculously, there'll be a local resolution that will extend that deadline, sometimes even after the fact, and you can always check. But normally, it's a drop-dead deadline. If you cannot redeem in time, and most of our clients can't, they can't come up with all the money to pay their taxes off. It's really critical to file and serve an answer on or before this deadline. There is no such thing as a late answer under Article 11. It will be rejected, and your default judgment will be entered very quickly, sometimes even within days of the deadline. Dire consequences. In a mortgage foreclosure, if your client's home sells and there's a surplus, they get it back. Well, unfortunately, under the real property tax law, you do not get anything back. So anyone with an interest who fails to redeem or answer, this is the consequence, and I'm going to read it because it's really, really strict, shall be forever barred and foreclosed of all right, title, and interest and equity of redemption in and to the parcel, and a judgment in foreclosure may be taken by default. So basically, that's even not only the homeowner, but any mortgage companies or lien holders. They get nothing. The municipality keeps it all. And you could owe $500 in taxes and lose a $100,000 property, and the municipality will get to keep that. And this is why the mortgage companies, if anyone was ever wondering why did they pay back taxes while the mortgage foreclosure is going, well, they don't want to lose their rights in the property either. Because if the foreclosure goes through, they're out of luck too. How to redeem. So we'll talk about the 3 ways to respond to a tax foreclosure. You can redeem, you can make an installment plan, and you can answer. So first we'll talk about redemption. The homeowner or any other interested party, and that includes the mortgage company or bank, can redeem. You got to pay the full amount of the tax due, plus any penalties, interest, or other fees. And this is an interesting part of it. The tax liens get redeemed in reverse chronological order. The newest liens get redeemed first. It's kind of hard to understand, so I have an example here. In this example, John has unpaid property tax liens for 3 different years. He's got $1,500 for 2012, $2,000 for 2013, and $2,500 for 2014. So he gets served with a foreclosure petition for his 2012 tax lien. And he thinks, well, I can stop the foreclosure by paying $1,500. So if he pays the $1,500, unfortunately, they're going to apply that to the latest lien, which is 2014, and that will reduce his 2014 to $1,000. But he's still going to owe the full $1,500 for 2012, so that foreclosure is going to go forward. So the moral of the story is, if you're going to redeem, you have to pay all the tax liens off at once. And in John's case, he would have to pay $6,000 all 3 years. Okay, moving on to installment agreements. Since most of our clients can't afford to redeem in a lump sum, some tax districts offer an installment plan. Not all of them do, but some of them do. So it's important to check with your tax district to see if they do. If you can make an installment plan on or before the deadline to redeem or answer, you can stop that foreclosure. If your tax district offers an installment plan, they are supposed to notify all the delinquent taxpayers within 45 days of when they find out who is delinquent for the year, or as soon as practicable. They have a little leeway. Okay, what kind of terms can the installment agreements have? Tax districts can offer at this current time up to 36 months. They don't have to offer the full 36. For example, the city of Utica only offers 12 months, but they can offer up to 36 months if they want to. The down payment can exceed 25% of the tax lien. Oh, I'm sorry, just going back. As of 12/31/15, that number is going to go down to 24 months. The state law, for 3 years, because of the economy being so bad, they allowed tax districts to go up to 36 months. But now it's going to be going back to 24 months. So the down payment can exceed 25%. Payments will be due on the last day of the month. Interest will be added for each month late up to 1%. Some tax districts may be a little different, but usually up to 1%. If you're 15 days late, you get a 5% late fee. And then you default if you're late for more than 30 days or if you fail to pay your subsequent tax bill. And it's important for your client to know that even though you're on this installment plan, when your new tax bill comes up for the current year, you've got to pay that or you're going to be back in foreclosure. So if you default, you will be heading back for the tax foreclosure proceeding. Okay, now for the third way to respond, and this is going to be the most common because most of our clients will not have the money to either redeem or do the installment plan. How to answer. And again, I stress, it is critical that you answer on or before the drop-dead deadline that's on that notice of petition and petition. The answer is very similar to in a mortgage foreclosure. It's got to be verified. It's got to state the nature of your interest in the property. For example, fee simple ownership or life use. You have to serve it on the attorney for the tax district, and that address is usually provided right in the petition. So whatever address is in the petition, that's what you're going to want to follow and use. Then you file your answer with the county clerk, and you file an affidavit of service. This is another very important point. That is very different from mortgage foreclosures. Sometimes we've had clients in mortgage foreclosures that did a pro se answer, which basically just said, I contest the foreclosure and I have this hardship or that hardship. In a property tax foreclosure, a general denial is not enough. You have to set forth any defenses you have in detail and attach any supporting documents to prove your case. Very few people file answers in these proceedings. I'm kind of shocked when I go file an answer and I look and either no one has answered, no one else has answered, or maybe one or two folks have answered. And the people that do, often they just talk about their financial hardship. This is not a defense to an Article 11 foreclosure. The tax district usually will move to strike those type of answers all at once in a bulk motion and say that they're not detailed enough. So don't let yours be caught up in the mix. Make sure yours has enough detail to survive that motion to strike or that motion for summary judgment. Okay, burden of proof. Tax foreclosure proceedings put the burden of proof on the taxpayer. If the tax district has followed all the procedures as we discussed earlier, they're going to be presumed to to comport with due process. So the taxpayer under Kennedy versus Mustafa, again, the tax debtor has the burden of affirmatively establishing a jurisdictional defect or invalidity in the tax or foreclosure proceeding. So the burden's on your client. And oddly enough, and this would not be true under mortgage foreclosures, this presumption even applies to minors, people who are incompetent, absentees, or non-residents of the state. And there's many cases on that. This is just one example, a third department case, matter of foreclosure of tax liens by County Sullivan. In that case, the client was Korean, or the respondent was Korean, couldn't speak English very well, and then he left the country for a while. And the court held that it was his responsibility to have somebody check his mail and let him know what was going on. And they really didn't care that he couldn't speak English, which would not be the case, I think, under a mortgage foreclosure proceeding. But because tax foreclosures are so strict, it's very hard to find an excuse as to why you didn't pay or answer. And that may be shocking to some of you. It was to me when I found that case. Okay, because these procedures are so complicated, I've developed a pro se answer form, which is with your. I put it in quotes because I don't think it's something your client is going to be able to do on their own. They're going to need your help, and specifically, they're going to need your help with you going to the county clerk and doing the research to see if the procedures were followed, and if not, identifying what was done wrong. I'm going to show you right now what the pro se answer looks like. Okay, and we have here basically some of the requirements are right here for you. All you have to do is check a box. For example, you have to state your interest in the property. So all you have to do is check a box here as to which of these fits your client. We even included when people have died, whether someone's an executor or administrator or an heir or beneficiary, whether they have a divorce judgment and the property was supposed to be put in their name, even if they were a tenant. So any of these that fits your client. You also want to identify, is it a residential property, farm property? And then there's some special protections for veterans, so we put that in as well. And then we'll get into the affirmative defenses. So we'll go through these, but premature filing, property in the wrong class, defective petition, lack of proper notice, improper filing of the tax list, the amount owed is not correct, demand for an installment agreement, and then there's a place for other defenses.
Cindy, you're at about 15 minutes now.
And then there's the verification page, and your affidavit of service is all set for you. So feel free to use that, and if anyone ever comes up with any other defenses, just add them. These defenses, again, are very technical, so most likely you're going to have to visit the county clerk yourself to see what defenses there are, and then come back and help your client fill out the pro se answer. Now, I do also want to say, this is not in my slides, but even if you don't have a defense, answer anyway, because it will satisfy that drop-dead deadline, at least for the moment, and hopefully give your client some time to either move or raise the money. Okay, expect blank stares. Most of these tax districts aren't used to being challenged in these actions. They get what they want, and they get what they want very quickly. So some of my colleagues and I have had this experience. If they're on call, they'll probably be laughing because we've gone to some of these rural counties and had people look at us like, you want to see what? We don't even know where that is. So every county clerk's going to have their own system with these cases. Some of them don't even have them on the computer with the other civil actions. It might be stuffed in some hole, and only a supervisor might know where to find it. So you just have to be very persistent. Sometimes they even allow the tax district or their attorney to take the files out of the clerk's office and have it in their own office. We had that one time. So be persistent. Go up the chain of command until you find someone. Usually there's someone that's been there for years that, oh, I know where that is, and they'll go find it for you. And if they resist, you got to remind them, this is public information. You have a right to see it. It doesn't matter that no one else has ever looked at it. It is public. We're going to go through some of the defenses that you can raise in a tax foreclosure. This is not exhaustive, but I think this is some of the more important ones. Number one is amount owed. You always have the right to dispute the amount owed if it's not correct. And some examples of that would be the taxes, penalties, interest, or other charges were not calculated right. That does happen, so check the math. Foreclosure charges of more than $150 can't just be added on. They have to be substantiated and approved by the court. So that includes attorney's fees, address searches. If it's more than $150, you have the right to demand a hearing to make sure that they can prove that. Improper denial of exemption. For example, if you applied for the STAR and you didn't get it for some reason, that can be a defense. Or payments not credited properly. You might have proof that your client actually did make some payments that did not get credited. There's a really great case on this. I encourage everyone to read it. It's a matter of foreclosure of tax liens by County of Ulster, a third department case. And again, the tax districts are used to getting their way with these matters. They're used to just getting a default and having nobody challenge them. So they resist having a hearing on a case. And this court held that summary judgment was not proper because there was a material issue of fact as to the amount owed. And the taxpayer had the right to have an evidentiary hearing, and ultimately the court went through the fees and charges being charged by the county and found that they did not comply with the real property tax law. And this case has a really great analysis of how you calculate interest, fees, and other charges on a foreclosure case. So I really encourage everyone to look at this case. Okay, defense, premature filing. Now this is going to get pretty confusing, so I really broke it out. The first thing you have to do is identify the lien date. So the lien date for unpaid property taxes is January 1st of the year when the taxes were due. So for example, if I failed to pay my 2015 taxes in September when the notice came, the lien date is going to be January 1st, 2015. So it goes back to the beginning. Unless local law sets a different date, so you always check your local law for that. There's a small exception. Sometimes school taxes get enforced together with other types of property taxes like county and village taxes. If they haven't been re-levied and there's two different dates, you always use the latest lien date. So for example, say if the school taxes were from 2014 and the county taxes were from 2015, you're going to use the 2015 lien date. Okay, the normal redemption period under the statute is 2 years from the lien date. So if my lien date is January 1st, 2015, I'll have until 2017, so I'll get 2 years. Now this is where it gets interesting. Tax districts can choose under the law to allow 3 or 4 years if they want for residential property or farm property. They can also choose to allow 4 or 5 years for veterans who have either been on active duty for 6+ months or if they've been killed in action. So check your local laws to see what redemption period is in force. So your client may have 3, 4, or 5 years to redeem, not just 2 years. And again, check with your local laws, check with the tax district and get their information. Once you know what the lien date is, then you can discover whether the petition was filed prematurely. So if it's 2-year redemption period, it's going to be premature if it was filed less than 21 months after that lien date. For 3-year, it's 33 months. For 4-year, 45 months. For 5-year, 57 months. Okay. And another point, and this is under the pro se answer under property in wrong class, sometimes if a client's property is not in the residential class or the farm class, like it should be, they're only going to get that 2-year redemption. So if they can prove that their property actually is residential or farm, they could potentially get the 3 or 4-year redemption. And in that case, you could ask for the court to dismiss it. So they definitely would need to provide proof. And residential is defined as a 1 to 3 family dwelling. Okay, another defense is defective petition, and this may be familiar to any of you who have done landlord-tenant cases in the past, because we were always using that as a defense. The petition has to be subscribed and affirmed under penalty of perjury, and it's got to be done by the enforcing tax officer. So who's the enforcing tax officer? Unless the local law provides otherwise, here's a list of the enforcing officers. For a county, it's going to be the county treasurer or commissioner of finance. For the city, it's going to be whoever is designated in the city charter, so you'll have to look at the city charter. For a town, it'll be the town supervisor. And for a village, it'll be the village treasurer. And I just want to note here, I know about this later, that some counties enforce taxes on behalf of their cities, towns, and villages. One example is Madison County. They enforce taxes for all their municipalities, except for one city that's opted out of the Real Property Tax Law, Article 11. So sometimes you'll see the county enforcing village taxes or town taxes. Another big defense is improper notice. Just note at the outset, it is much narrower than we're used to for landlord-tenant cases or mortgage foreclosures. The procedure for notice is pretty complex. The first step is publication. They have to publish that notice of foreclosure in 2 newspapers in general circulation in that tax district, and it's got to be for 3 non-consecutive weeks in a 2-month time period. They must also post a copy in the enforcing officer's office and at the county courthouse. Now, on or before this publication happens, the individual notices have to go out. So your client needs to be served with a notice of foreclosure and petition, and it has to be on or before that date of the publication. And it's got anybody who has a right, title, or interest in the property as a matter of public record. So as long as it's apparent from the public record that somebody has an interest in this property, they have a right to be served with those papers. That includes anyone who's applied for third-party notification. That's Real Property Tax Law, Section 1126. You can apply to be notified of the tax bills for a property. Usually this would be a mortgage company or a bank that has a lien on the property. Or it could be, say, there's a senior citizen whose son or daughter is helping them with their affairs, and they might be entitled to notice, and they apply for that. The notice has a very specific format to make sure that it covers all the taxpayers' rights, and the format is in Real Property Tax Law 1125, so you can look at that to make sure it matches. Okay, how far does the tax district have to go to notify people? They're only held to addresses that are, quote, reasonably ascertainable from the public record. But the public record isn't everything. Statute, it's only county clerk's records, surrogate court records for the county, and tax rolls within that county, and any changes of address that the taxpayer had affirmatively filed. Just having a check stub that has your new address on it or an envelope that has your return address on it isn't enough. It has to have been an actual letter from the taxpayers. I have moved, please change my address. Okay, other notice requirements. The notice to the taxpayer has to be by first-class mail and certified mail. If they're both returned undeliverable within 45 days, the tax district has to check with USPS and try to get an updated address. So if only one's returned undeliverable, they don't have to do anything else. That's very different from some of our other landlord-tenant and mortgage foreclosure cases that we deal with. If they do find the alternative address with the post office, they have to serve at that address again by certified and first class. And the client's going to get a little extension if this happens. The drop-dead deadline that we talked about to redeem or answer is going to be until the original drop-dead deadline or 30 days after the mailing, whichever is later. So that might give them a little extra time. If they don't find the owner's address, the alternative address, they have to do posting. And the posting is posting the notice of foreclosure on the property. It's got to be on a door or on a telephone pole or something that's vertical that's visible from the road. And again, the client gets that 30-day buffer if that does happen. If they find somebody of suitable age and discretion on the property, they can decide to serve that person in addition to posting or instead of posting. And then finally, if the owner is listed as unknown on the tax roll, they have to serve the occupant by first-class mail and posting. So those are your notice procedures.
Cindy, you're about 30 minutes in.
And another defense, which is, again, this stresses the importance of going to the county clerk. You really have to physically go there, is Defective Tax List. Under Section 1122, the tax district has to file a list of delinquent taxes every year with the county clerk. It's got to be filed 10 months after the lien date or as soon as they can, but it can't be filed any sooner than 1 month after the lien date. And the copies also have to be at the tax district's address, and if there's any other tax districts like a village or a town or county, it should be filed there too. And again, it's critical to go to the county clerk's office and review this list. Missing information on the list has been found to be grounds to dismiss a foreclosure petition. And an excellent case on this is another third department case, matter of foreclosure of tax liens by County of Delaware. And on the next slide, we will see some of the information that could be found to be missing. Okay, required information is a brief description of the property. Usually that's the address and the tax ID number, the names of the property owners from the tax roll, the amount of each tax lien on the parcel, including any charges as of the date the list was filed. It's got to be subscribed and affirmed, again, by the enforcing tax officer, and it's got to be filed within 2 days of when it was executed. Now, in the County of Delaware case, a number of these items were missing, and actually I have seen that too. I had a case recently in Otsego County where there were absolutely no tax charges listed, and we used that as a defense. Okay, so after you answer, what do you do? Some tax districts do nothing for quite a long time. I had one case that sat for a year after we filed, giving us plenty of time to get the taxes paid off. But others are quick. You might see a motion to strike or a motion for summary judgment within a month or 2 months that you need to respond to. And again, if there's issues of material fact, you have the right to a trial, and that's set forth right in Section 1130 before the judgment can be entered. And sometimes you have to insist on that because the district is used to getting its way without having a trial. And if ultimately you win the case, the court can dismiss the petition with or without prejudice as they see fit. Usually it's going to be without prejudice. Okay, and here's some other defense strategies that you can use. We had already talked about redeem, make installment payments, or answer. Here's some other defense strategies. If you have a mortgage on the property, alert the mortgage company that there's a foreclosure. They're usually going to redeem because they don't want to lose their rights in the property. Apply for New York State. Unfortunately, I just learned yesterday that that program will be closing at the end of September. So get those folks in if you still have any that could benefit from this. You can apply to, as long as it's not really that high, you can apply for emergency assistance at DSS. They will sometimes pay off the taxes to keep the client in their home. Next, a really big one is file for bankruptcy. If you file for bankruptcy, either Chapter 7 or 11 on or before the date to redeem or answer, the automatic stay goes into effect. And another huge benefit under Chapter 13 is that your client can have 5 years, 60 months, to pay off the tax arrears. And I have done this successfully for several clients. And if your client can't make that installment plan, Chapter 13 might be the way to go. They might be able to stretch it over 60 months. If you can't do a bankruptcy yourself, make sure they get to a private attorney. Private attorneys do these cases and they know what to do. If anybody is handling one or wants to handle one, feel free to contact me because I've done them and had a lot of experience with that. And then finally, always check with your local government. Sometimes they will enact a resolution extending the time to redeem. Some of the districts, we actually saw that happen recently in Herkimer County, where the town of Herkimer, Village of Herkimer, I'm sorry, had a resolution that allowed people an extra month, even after the defaults were entered. Okay, at the final stage, if you lose the case after trial, or if you didn't redeem or answer, a default judgment is going to be entered. The tax deed is going to be executed in favor of the tax district. It will be recorded in the county clerk. And then eventually the property will be sold at auction and a third party is going to be taking title to the property. Okay, claim to surplus. This is an issue that comes up when you answer. If you answer, does that mean that you can claim that surplus if your property ends up being sold? Well, it's really unclear. There are some cases that kind of indirectly suggest that that is the case. So we put that in our pro se answer at the very end, a demand for the surplus. And here's just a list of a few cases. There was a U.S. Supreme Court case, a federal court case, and also a Fourth Department case on these issues. However, I'm kind of doubtful personally of this because Section 1136 states that if your answer does not have merit, the judgment will be entered and your right and interest and equity in the property will be foreclosed. So I'm not all that optimistic that that would be successful, but there's the case law. If you want to argue it, you can certainly argue that. And again, if you did not answer, you're not getting a surplus. It's not going to happen. Okay, what if your client missed the deadline? There's a small window of opportunity here. If it's still 1 month after the entry of judgment, you can file an order to show cause to reopen that default judgment. This deadline is beyond strict. This is only one of many cases that I've cited here, that if it's even 2 months after, it's not going to fly. So get it in within 1 month. We actually did that just this past year for a client who didn't speak English, and she thankfully got her papers to us just in time. One of our attorneys, Jay Flemma, filed an order to show cause and was successful, and she was able to save her home. You must show reasonable excuse and meritorious defense. And we're just warning here, get an actual copy of the judgment. In Jay's case, the tax district told him that the deadline had already passed, and it turned out not to be true. The judgment hadn't even been entered yet. So definitely don't rely on what you're told over the phone. Go down there, get a copy of it. Okay, now for the Hail Mary pass. If all else fails, your client has the right to challenge the tax sale with an Article 78. And you also have to file a lis pendens with the county clerk when you file your Article 78. You have 2 years from the date the tax deed was recorded. If fraud was involved, for example, if the tax district did it on purpose, they concealed information, or the new owner concealed information, it could be more than 2 years. This is a very, very tough standard of review, however, and I have not found one case where one of these was successful. An example of an unsuccessful case is the matter of John Stone out of the Fourth Department. So I would not get your client's hopes up, but certainly it's out there. Okay, and we're getting towards the end of our presentation now on the Article 11. What happens after the tax foreclosure and the tax deed? Well, your client will be evicted. There's 2 different methods. One is under the Real Property Tax Law, Section 1162. You can apply for a writ of assistance to remove any occupants from the property. Or you can go under what our landlord-tenant advocates know as RPTL, Real Property Actions and Proceedings Law 713, where they get a 10-day notice and there'll be a summary proceeding filed with the city court or the village or town court. Sometimes new owners are open to negotiate more time or enter into a lease with your client. I had one case where the city took over and allowed our client to stay the landlord hasn't foreclosed upon, and our tenant was given 4 months to move, which was more than she needed, and she did fine. Okay, and then an ounce of prevention. A lot of times your clients get in trouble in the first place because there were exemptions out there they didn't know about, and they're paying way too much tax. So while you're defending the current tax foreclosure, it's important to look at their taxes and see if you can lower that burden for them going forward. It's no good to get a MAP grant to pay off the back taxes if your client can't afford the ongoing payment. So here's some things to consider. Make sure your client is on the STAR program to actually check their bills to make sure. There was a re-registration back in 2014. Those of you who are homeowners know that you had to go online and re-register. But if your homeowner missed the deadline, they can still do so. So just go ahead and do it. Send them down to the assessor's office and have them register. Seniors who are 65 and over and low income will qualify for the enhanced STAR, but that's not automatic. They have to apply for it. They have to go down to the assessor and apply, and they have to recertify every year. And STAR, for those of you who don't know, is school tax relief program. So that will lower your school tax burden. And for seniors, that can be huge. Sometimes they won't have any school taxes at all, so that is a huge benefit. Okay, and then some tax districts, I was surprised to learn, might have additional exemptions. Seniors, veterans, low-income people with disabilities, that was a real surprise to me, and then farm properties. The one for seniors is different from the school tax. That's for county and village, all those other taxes. And I have a client right now whose tax burden went down from about $250 a month to $100 a month because of taking these steps. I have a veteran who's paying like $90 a year for her taxes. So these are really good benefits. The deadline is usually going to be March 1st, but check with your local tax district because some have different deadlines. And these tax savings can really be substantial, and they can really ensure that your client is going to keep their home going forward. Okay, and then finally, other prevention strategies. You can help your client grieve their assessment if it's really out of whack. I'll give you an example. We had a client living in a very rural county who had an old log cabin who was really run down, not worth a whole lot, but these really expensive homes went up all around him. So one year, all of a sudden, his assessment doubled, and he was on SSI, and there was no way he was going to be able to afford to live there. He was going to be forced right out. So you can file a tax grievance. Usually it's the 4th Tuesday in May, but make sure to check with your local district to get the exact deadline and information about how to apply. So in his case, we applied. We got an appraisal, which is really important. The appraisal showed that the property was not worth even near to what the tax district was claiming. The tax district doesn't have much incentive to work with you because that means there's going to be less money in their pocket. So often you will have to appeal, and in his case, that's exactly what we did. There's an appeal process called Small Claims Assessment Review, and we were fortunate to get a pro bono attorney who did a wonderful job and convinced the court, these claims go to usually the Supreme or County Court, convinced the court to keep the assessment where it was. Okay. And then finally, teach your client how to escrow. Many of our clients have a really hard time because the bills come due maybe once or twice or 4 times a year, and they really just can't budget. So take the total taxes, divide them by 12, and tell your client how much they need to save each month. Try to get them to open up the savings account. I had one client with very limited income, and she came in and I said, what is the savings that you do every $100 every month? What are you doing that for? And she said, oh, that's for my taxes. I just gave her a huge pat on the back because on her limited income to do that was a wonderful thing, and made sure that she would never have to face the foreclosure. Okay, and then just finally, resources. These are just some links to websites where you can get more information. There's the STAR program, other property tax exemptions, and how to contest an assessment, and then also a brochure on the Small Claims Assessment Review. So I hope you find these useful. Thank you very much.
Great. Thank you, Cindy. So we've got a couple of questions that we can address now. So you had a slide previously, but maybe you could spend a minute just clarifying it. So if a county has opted out, does that only cover the county taxes, or does that also cover the cities, so the city taxes, the town taxes, and village taxes within that county that had opted out?
Okay, that's a very good question. Actually, it only covers the county taxes. So, as an example, Oneida County, the county I practice in mostly, has opted out. So Oneida County taxes are subject to a whole different process than the one I just talked about. But our cities, most of our cities and villages and towns have not opted out. So, for example, the city of Utica is in Article 11, and it's within the county. So, yes, county opt-outs will only apply to county taxes. City opt-outs will only apply to city taxes.
Okay. And then there's a comment about the recommendation for people to save money for their taxes, for their escrow.
Yes.
So if you are an SSI, that can be an issue, right? Because it can be considered a resource?
Yes, that is a very good point. You have to be very careful with that, because if your client has more than $2,000, even one penny more than $2,000 at the beginning of the month, they could lose SSI for that month. So be very careful with that and make sure your client is staying under that limit.
Okay. And then a general question that I think I answered privately, but I think it might be helpful to just say it out loud. The pro se answer that you have provided as an example for folks to use, do you recommend that housing counselors help homeowners fill that out, or do you recommend that the housing counselors refer those homeowners to an attorney?
In this case, I think I would recommend that they send them to an attorney, just because it's very technical, and because it has to be so detailed. A lot of the sections of the law are quoted. I quoted them right in the answer. So I really think that's probably something they should refer.
Okay. That's all the questions for now. So, Paul, do you have control of the screen yet?
I do, and I'm going to click show my screen, and then you can tell me if I've got everything set up right.
Sure.
All right.
Lovely.
Okay, perfect. So thank you, Cindy. That was really great. That was a really thorough introduction to Article 11 foreclosures. I'm just going to fill in some of the other issues that people might run into, specifically in opt-out jurisdictions, and also for those of us that have to deal with the tax certificate sales. Just real briefly, I've been doing in-rem defense in Buffalo and Erie County since about 2001, and I would not be able to do it and maintain whatever level of sanity I have without some really great community partners, and I have to shout out to them. Specifically Dan Webster and Kevin Quinn at Legal Services for the Elderly, Disabled or Disadvantaged, and also Joe Kalaman, Lauren Breen when she was there, and Matthew Parnham at the Western New York Law Center. We have a great network of people, and the first thing that I would say is, if you're working in an area and you can establish local networks, we certainly do it in Erie County, but especially if you're working over multi-counties, find out who the advocates are in the different areas, and even if you set up some sort of informal, I don't know, network or task force, it can be very helpful, especially in areas where the tax foreclosure season is not regular, and I'll talk about that a little bit later. So I'm going to start just by talking about the concept of the opt-out. When New York State decided to allow jurisdictions to opt out, basically what they said was, if you're using a tax foreclosure system already, you can maintain that, but you have to let the state know that you're doing it, and it has to be it has to be a procedure that you're held to the same way you'd be held to Article 11 foreclosures. So Real Property Tax Law Section 1104 speaks to how that was set up and what the requirements are for the opt-out. As Cindy mentioned, there's a website. New York State Department of Taxation and Finance maintains this list. You can go on. You can see what jurisdictions are there. You may want to note, depending on where you are, that sometimes the counties opt out and the city is not, vice versa. And we'll discuss sort of some of the complications that arise from that, because it can get a little bit tricky. So I urge you, if you're going to be doing any of this work, to take a look at that list, see where you're, where you are on that, and then if indeed you're working in an area where the tax district has opted out, probably the best first step is to contact your tax assessor office and find out if they can get you a copy of what statute they're using. I have found tax offices to be really, really helpful in getting you that information, so it's not something that they're going to think they're handing over some sort of ammunition to defense attorneys or anything like that. They often comply very quickly, or if they've got it on their website, you can download it. So one thing to look out for is if you have a municipal tax district that has opted out, so they're using their own old code, but then they say, we're not really going to get involved in this. The process can be expensive to a municipality, and so they say to the county, hey, we're going to let you enforce all the unpaid taxes. And so noted on the New York State website is that 6 villages in Wyoming County opted out, but then agreed to let the county, which was non-opt-out, handle the in rem foreclosures. So this can be a problem. You might come across information that a village has opted out. It's very important to contact that tax office and say, and I see that you've opted out. Is that how you're proceeding? Because they're obligated to tell you if they are or they are not. So if you were doing some work in one of these villages, you would want to talk to the tax office, make sure that you realize, okay, but the procedure they're using is actually Article 11. It can have consequences, so you definitely want to do it. And if I'm running through this really fast, I apologize. You can either stop me or we'll answer questions at the end. As I've said, the tax districts have to come to some agreement. As we saw in Wyoming County, there were 6 villages that opted out, but then had the county take care of their procedure. We're in a strange situation here in Erie County. Erie County is an opt-out district, but the city of Buffalo is not. So the city of Buffalo is Article 11, formally, and the county has its own older code that they follow. They've resolved things. People might not be aware of this, but Buffalo has an enormous in rem sale every year. It really is. It's depressingly active every year. The county has decided not to enforce within city boundaries, so there's no fight for who gets to do the in rem. This allows advocates a little bit of relief because we're not fighting 2 different tax districts, and for the time being, they're sticking to that plan. So if you're in the city of Buffalo, you know that you're Article 11. If we get a call from someone out in Erie County, though, we have to check to see if the villages have opted out or what the status of that would be, and then follow Erie County procedure if that's what controls. As Cindy mentioned, there is also a note on the website. The village opt-outs are only relevant to delinquent taxes that became liens from 1995 through 2009. So that's another thing. We find when we're doing in rem defense in the city, we're often not just fighting the most recent year's tax bills, but some of them are quite historical. And so you need to know what years you're talking about when you're putting together your defense. And in those villages, that's going to be really significant because you might have to be dealing with, in the same petition, a different approach to these liens that came due in those years. I've listed 2 cases. I know that our main focus today is specifically preventing the foreclosure of the NREM, but I wanted to point out a couple things that have arisen because of a misunderstanding of opt-out, non-opt-out. In particular, this bankruptcy court case, Wysocki versus Ontario, it found that the foreclosed, this was a case where someone tried to file a Chapter 13 to prevent a tax foreclosure, which is totally standard. When we have our annual NREM in Buffalo, there are people filing Chapter 13s. I wouldn't say a lot, but it's one of those things. If you can't do anything else and you're able to come up with a reasonable plan, people will file a Chapter 13, and sometimes it works, which is always great. The problem here was the person who filed, and just a footnote here, I'm not criticizing the attorneys here at all. I have been this attorney, you know, people do miss these things. This is somebody who filed the Chapter 13 after the judgment was filed, but before the sale. Now, if you do that in Buffalo, you stop the sale. The problem is the jurisdiction where the house was located was an opt-out, and one of the things that the opt-out language said was its title transfers to the county when the judgment is filed. Now, that's not true in, for instance, in Buffalo in Article 11, where the title doesn't transfer until the sale is completed. So in this case, these people thought they were saving their house with a Chapter 13. The bankruptcy court said, no, you didn't own the house after the judgment, and therefore you couldn't include it in the bankruptcy. So that meant that that house actually then went up to sale and was purchased by an independent buyer. Now, for all I know, they filed that bankruptcy as quickly as they could. But the fact of the matter is timing is very important. And if you file in an opt-out district a bankruptcy, you need to know where you are in the procedure, because that title can transfer as soon as the judgment is signed and filed. So that's one case where knowledge of what code was controlling the NREM was crucial. Another situation, the AJM Holdings versus Cortese, is a landlord-tenant case, and here I can identify very, very much with the attorney in this case too. This is an attorney who their office and said, we've been foreclosed and they're evicting us. And the attorney looked at the statute, and heavens, this foreclosure statute was invalidated basically in 1993, and so they filed their defense saying they didn't follow the correct foreclosure process, therefore they can't evict. This is something else that I can identify with this attorney on, quite frankly. What they didn't do is they didn't read the rest of the statute, which said, however, if you choose to opt out, you can use this procedure, which is exactly what the municipality had done, and therefore the court ruled that the foreclosure was properly done because they had opted out. That's just a cautionary tale in dealing with these with statutes that involve first mentioning the repeal and then how to reestablish the thing that's been repealed. So it's important as advocates in general to understand, if we're going to be working in property law, the distinction between opt-out and Article 11, but also to know how different the actual time frames and ownership of the property can be. The fact of the matter is, when we're doing them in Buffalo, we bring orders to show cause, and we can bring bankruptcies up until the gavel has fallen in the sale. That's not going to be true in an opt-out. It's not going to be necessarily true, I should say, in an opt-out district, depending on what that statute says about transfer of title during the process. So we got to be very careful about that. As I've said, I've had good luck in surrounding areas getting the statutes from opt-out tax offices. I don't think it should be a problem. It's also best to go directly to the source. In looking through this and other, well, I think pretty much anyone on the line has seen all the stuff that you can find out about foreclosure in general online. Some of it is useful, and some of it is so ridiculously wrong that you don't even know where to start. So I would be very careful about stuff found on non-official websites and blogs about these issues, because I have found some really, really crazy stuff. Switching gears here, because I see that we've got, okay. Talking about districts that allow either individuals or specified corporations to buy tax liens, tax certificates. Tax districts can establish the procedures for this. They can also get rid of them. Erie County, for a number of years recently, allowed for the sale of tax certificates. It didn't work out, so now they've switched back. So you want to pay attention to your local government to see if they're planning such things. I think right now there are the counties of New York City and Nassau County are the only ones in New York that allow for tax certificate sales. And they seem to do them in different ways. New York City, there's actually an entity that's been set up that purchases them and then maintains whatever plan they're going to have for their certificates, they take care of. Nassau has an annual sale, which is what Erie County had been doing. And you'll see if you're in Nassau County, that's Nassau County Charter Section 2201. I've given the site for the enabling statutes for New York City also. There are there's some issues that I've found when we were dealing with tax certificates that I think advocates should be aware of. When we are dealing with when we're dealing with pending in rem sales in Buffalo, we actually, I wouldn't say that we get a sympathetic hearing from the city, but certainly the city, together with our process whereby we go in front of a judge under order to show cause, we get a hearing and we have a judge who's willing to maybe try and, I don't want to say force, but enable some sort of stipulated payment plan. My experience is twofold. One is we know every year when Erie County and Buffalo are going to do their in-rem sales. Totally predictable. We put together a team to deal with the city sales. Other people can calendar when they're going to gear up for county sales. Issue number one with the tax certificates is if you have an office that deals with the in-rem on sort of an annual basis, this messes it up because the sale, the foreclosure sale, if initiated, can happen whenever. Now, this probably doesn't seem so terrible to those of us who do a lot of mortgage foreclosure stuff because we're doing that throughout the calendar anyways. But it can be a little bit of a scheduling area for offices that are concentrating on in-rems once or twice a year and then all of a sudden have them appearing on a rolling basis. So it's something to be aware of in terms of advocacy. It can be a resource issue, quite frankly. Investors are also they're not municipal employees. If you have someone who's friendly in City Hall or in County Hall, they may, I wouldn't say give you a break on specific cases because they can't, as Cindy has mentioned, but they may be more willing to hear in general the concept of equity and equitable defenses for folks. They may, my experience, limited as it is that government employees are a lot more sympathetic in general to arguments about poverty and people having financial issues that are beyond their control. Investors generally can't. I mean, especially if they're answering to to their corporation, they can't bend on these things, and they generally don't. So if you're used to having friendly or at least sensitive negotiations with your city or county, negotiating with a corporation is a whole different world, as we found in the world of HOPP. So some of the mortgage companies, it's almost like there's not a person there. So it can be much more challenging in that respect.
Paul, we have about 20 minutes left.
Okay, I'm gonna finish up real fast.
No worries.
So that's what I mean when I talk about developing a degree of rapport with your opponent. That may sound silly to some people depending on their experiences, but I found it to be really true in the in-rem world. I have found it to be, as I said, not true when we're dealing with someone who has purchased a bunch of liens and is thinking to foreclose. I just want to talk about a couple things. One thing about the tax certificate issue is probably different in different parts of the state, but one of the things that we found was the fact that people bought tax certificates, we assumed was going to be, and this was before the mortgage foreclosure crisis, we assumed it was going to be sort of a wave of foreclosures and tax sales, and exactly the opposite happened. It was sort of our first experience of zombie properties, because we had people who the county no longer owned their tax lien. They weren't making any more tax payments, but nobody was moving forward with any of the foreclosures. So we had a bunch of homeowners that were in limbo the way a lot of our mortgage foreclosure clients are currently in limbo, and that was our first experience with that. Fortunately, in Erie County, the decision was made because of that to buy back the certificates and sort of start from scratch. But different people may have different experiences downstate. Certainly in the city, I'd be interested in hearing from advocates there to see what their experience has been like with tax liens and certificates. I also wanted to point out an issue that cities with severe housing problems, the problem with the Article 11 sales that we've had is, unlike the county, the homeowner doesn't lose title until the new purchaser has completed the purchase, which means we have people who have been, if we're unsuccessful in preventing the foreclosure, we often wait to see if someone bids on the property. If no one bids on it, it reverts completely back to our client, our homeowner. But then the city allows individuals to bid and then make a couple payments. It may take a year for someone to fail to complete a purchase after doing the bid. This is a terrible situation for many reasons, not least of which it's psychologically horrible for our clients, but it also it puts our clients in a position where they don't know whether they should be fixing the roof, for instance. Just like our clients who are stuck in mortgage foreclosure limbo, they don't know what they should be doing with the property. Now, Buffalo has a pretty aggressive housing court, and it's a code, health code and structural code violation court, and so this becomes a very, very critical issue for a lot of our clients. We couldn't stop the sale. Someone has bid on it. They haven't completed the sale, so it's still in our client's name until a sale is completed. Meanwhile, they're defendants in housing court. So, this is maybe more of a point of advocacy and might not be applicable to a lot of people's jurisdictions. But if you are in an Article 11 world, it is critical to find out, okay, what next? What's going to happen to this property while we're waiting to see if the sale is going to be completed or not? And then you have the uncertainty that obtains when somebody just walks away from a house. And we have had people who thought that a sale was completed, left the house, only to find out that it reverted to their name, mainly because it was never out of their name. So that's just something to be cognizant of. We also, I don't know what the experience is of people statewide, but we've had, especially the Law Center has had great success here in trying to get the city to come around to a more reasonable approach to their tax bills. Specifically, the Law Center brought a class action suit against the city to make them comply with the concept, if nothing else, that the penalties and fees should be based on real costs to the city. So it is worthwhile, if you think your tax district is getting out of control in terms of costs, to look into them and to try and push them towards a more rational approach. Just a quick example of that, we have an in rem fee, and after a certain date you can't redeem without paying the fee. Well, the fee looked like it was $400 plus a number that reflected the in rem number that we were in. So for 1 year it was in rem number 39, and so the fee was $439. And the next year it was in rem 40, and the fee jumped up to $440, which was sort of patently random. And so you know, if you notice that there are practices like that really aren't tied to their costs, it's definitely worthwhile pushing the tax district to come in line, at least come up with an explanation as to why that fee is what it is. We also had, because it was $400 plus, we had some people who were basically being foreclosed on for a tax bill that was less than the fee, and then all of a sudden they had to pay both, which is something that's absolutely worthwhile fighting for. So if districts are foreclosing for small amounts, just fundamental fairness, I think, kicks in, and advocates should be pushing to eliminate that practice. We have also an issue in Buffalo that maybe other folks don't have, where water bills and user fees are bundled into the in-rem process, which a lot of us think is not really correct. So if you do have that issue, that might be something, especially with municipalities that have privatized water companies, it might be something that would be a good point of departure for a statewide task force on in-rem procedures. Other than that, I think maybe I'll end there, and we'll see if we have questions.
Yes. So there's a couple. Go ahead.
This is Cindy, real quick. I just wanted to chime in on what Paul said from the Article 11 standpoint. If you have these sales of tax liens to third-party companies, such as American Tax Funding is one of them, if they foreclose, they have to use the Real Property Actions and Proceedings Law, Article 13, just like in a mortgage foreclosure. So I did want to add that. Thank you.
Right.
All right. So let me dive into a couple of questions that we have and see where that leads us. So one of the questions actually has to do with HECMs, so for reverse mortgages, and it's a little bit different from what you're talking about, but there's just a request for the expertise of the two of you. So aside from requesting a repayment plan with the servicer or applying for MAP, when the reverse mortgage company has paid out the delinquent taxes, and now, of course, that reverse mortgage is now considered delinquent, right? Do you have any other suggestions when homeowners are facing a HECM tax foreclosure? Do you have anything to add? And let me just quickly mention that there is a webinar that we held, Sarah Mancini from Atlanta Legal Aid, and we did have that webinar in June. So that question there was some input on that question back in June. So if you have some more questions about that, feel free to go online to our portal and view that webinar again. So sorry, go ahead, Paul.
Rebecca, my quick response is I have to plead practical ignorance. I know conceptually about this, but I have not had a case, so I don't think I would have anything practical that I'd be able to add.
Okay, this is Cindy. If a mortgage company has paid off the taxes, you're really out of the tax foreclosure realm, and I think you have to look more to regular mortgage foreclosure defenses. And again, while you're doing that, you want to look at the strategy of reducing the tax burden, because many of these seniors that have the reverse mortgages have not taken advantage of the tax breaks, tax exemptions that might be available to them. But again, it's not something, it's out of the Article 11 at that point because the taxes have been paid, so the tax district's not going to be going after your client. So I'm not sure that that's helpful, but
no, actually, I think that's the exact answer, right?
Yes.
I just wanted to add one thing. It is, as Cindy said, it's shocking to see how many people who qualify for tax breaks are not getting them. And occasionally, even our city tax office will contact us and say, please have your client contact us about things that they qualify for. It's amazing how people are not taking advantage of those.
And also, don't wait. If you think your client may be eligible, even though it's not around March yet, you can have them go down and apply now. It's not going to affect, it's not going to take effect till next year, but at least their application will be in, so go ahead and do it now.
Okay, so I don't have any additional substantive questions for now, but there was a question about HOPP funding. So for those of you who are representing folks facing tax foreclosure, just a friendly reminder that absolutely these cases count under HOPP. So feel free to fill out your lovely Excel spreadsheets for us for those cases. And if you have questions, because they don't quite perfectly fit into all of those lovely fields that we ask of you to fill in, but if you have questions about it, basically the answer is do the best that you can with whatever you have. If they don't have a mortgage, which many of these folks don't have mortgages because typically they would have been paid by the mortgage company if they're delinquent with their taxes, give us a call, give me or Alex a call. We're happy to walk through what makes sense for your report.
Becky, I had just a few more comments. I did want to, I know I stressed that really compassion sometimes is not an appeal to these folks in the tax districts, even if they want to help your client. Sometimes the law ties their hands. But that doesn't mean that you shouldn't raise those issues. I think sometimes, say if you're in front of a judge and, they hear the sad story that your client is facing and they see a notice problem or they see that something wasn't included on the tax list, that may be their justification to give you some relief. So definitely the order to show cause that we did for the client that was in default is that we did timely. She didn't speak English. They hadn't provided an interpreter at the tax district. She didn't understand how much she had to pay. We raised all those issues. She was also a senior too. And we raised all those issues. And I think in the end, the tax attorney really wanted to help us. So once we answered, the attorney for the tax district was more than willing to let her pay. She had money at that point to let her pay the taxes. So definitely still raise those issues. I just want people to know that you can't always rely on that. And then finally, there's sort of just a Hail Mary path. Some tax districts will not let the owner bid at the tax sale. Others will. So that can be something, once the home goes up for auction, the homeowner, if they can get the money together, might be able to bid at the auction. I wouldn't rule it out, or they might have a relative try to bid. So those are some other, other possibilities.
Okay, so for now I don't see any additional questions. So Paul and Cindy, do you have any last closing thoughts before we make some final comments?
No, I think it is an area that would be helpful if if people are doing this kind of work across the state. It would be great for us to have a network. It's awesome that we're able to do this under HOPP. I do think it's the kind of thing where it might come up often enough that people become proficient in their local practice, but if not, it's something that definitely you can reach out to practitioners in neighboring counties or cities. And I think there's a lot of people statewide that have a lot of experience, so we should be talking to each other as things come up.
Yes, So I will piggyback on what Paul said, and just maybe it's because I happen to wear a HOPP hat quite frequently. But we have a number of different avenues that we have tried to create through the HOPP network to encourage exactly what Paul is talking about, which is utilizing each other. And especially for those of us who are upstate, we can sometimes get stuck in our little bubbles, in our little counties or wherever they are. And we encourage you to utilize the Settlement Conference Workgroup listserv. We also have monthly calls that we have, that this is something that absolutely you can bring up on those calls, those monthly calls. If you happen to be in my service area, so Cindy and Paul are both within that world of mine, we have monthly calls just for attorneys to talk about nuances of these legal issues that come up. So please, please, there's lots of avenues for you to ask your questions, and you're always welcome to call me or anybody else around the state for that matter. It's quite the helpful bunch. Okay, that's my little soapbox there. There's also actually one more area. There's a New York State, the New York State Bar Association has a public interest committee, and some of these issues might be, when you talk about the advocacy piece, that might be an area that if you wanted to be a part of, it's another road that you can use to try to affect some change that would be helpful for our clients. So I've just thrown a lot out there, but if you have any questions about any of that stuff, please feel free to let me know. On that note, typically we have one webinar a month. Last month we happened to have 2 webinars just because of some schedules. And next month we will not have any webinars. However, we are doing a tour to a city near you. We will be in Albany on Friday, September 18th. We'll be in Long Island on Friday, September 25th, and we'll be in Buffalo on Wednesday, September 30th for an all-day training on litigation, not tax foreclosure, but some basic litigation of these foreclosure defense cases. The intended audience really is for folks that have been doing this for a couple of years. You really want to become a bit more proficient in how to look at filing these answers, some discovery issues, objecting to summary judgment motions, those sorts of things. So I encourage you to register. They're free if you are, of course, a HOPP grantee, and it'll be an all-day training. So please, and we'll feed you. That always helps, right? We'll feed you.
Mm-hmm.
So please sign up for that. And we have some folks from Buffalo coming around the state, which I'm very excited about. So anyway, there we are. I don't see any other questions. So on that note, we have 3 minutes. No, I lied. 1 minute before 1:30. So Paul and Cindy, thank you again so much for putting this together. This was great and extremely practical and helpful. So thank you.
Thank you.
And that's it. Have a good day, everybody. Oh, wait, Michelle, do you have the code that you want to announce the code?
Yes, the CLE code is RKL49. So that's R as in Robert, K as in King, L as in Larry, 49. And to follow up with what Becky was saying on the three trainings that we're holding in September, if you did not receive the announcement for that, email me directly and I can forward that to you if you're interested in registering.